Okay, guys, I just wanted to give you a little more information on the California situation. I had asked you to take a look at this book, the edition of the Myers-Millis-Brown thing, the sort of a pocket edition. There is a similar manual, if you want, for every one of the other public sector labor laws in the state of California, but this is the most common one that's used because it's used for local governments. And it's different than the others because California is a sort of a radically decentralized state. It allows a tremendous amount of authority to be decentralized to the county governments and through the county governments to the city administrations. And one of those areas that's been decentralized, heavily decentralized, is the management of labor management relations. At the state level, for example, there's one piece of legislation covering all state civil service employees. However, the county and the city level, you've got a tremendous variety of options. And those options have emerged because of the passage of the Myers-Millis-Brown Act, which is referred to as a home rule statute. In other words, the ability of the local government to determine what constitutes wages, hours, and conditions of employment as subjects for negotiation are allowed at the local level. And sometimes, of course, that causes some controversy because if you work in LA, you have one set of standards, and if you work in Orange County, you might not be subject to another. So that's one of the controversies that arises out of it. But under the Myers-Millis-Brown Act, and the reason I've asked you to take a look at this, is that it deals and outlines how a tremendous number of the technical issues involved in establishing the relationship between the associations, public employee associations, and the local management are to be determined. And if you look at the crucial things, in the introduction table of contents, it talks about the recognition of employee organization. It looks at the bargaining unit determination. A bargaining unit, as we'll find out later, is the group of employees that, for purposes of collective bargaining, are clumped together, organized together. One of the earlier arbitration cases I dealt with in San Bernardino was the public defenders wanted to be in a separate bargaining unit from the prosecutors. And they did an unusually silly thing for lawyers. They represented themselves before the board that I was the chair of. And there were 100 of them. And they really were too small to form their own separate bargaining unit. It's too small a number. And so they lost. But in doing so, they sort of made clear the reality of that phrase, don't trust yourself for a lawyer. Don't ever hire yourself as a lawyer. So anyway, the Myers-Millis-Brown Act covers issues of bargaining unit determination. At the state level, that's determined by PERB, P-E-R-B. At the local level, it depended on the jurisdiction. It looks at organizational security. And that's a term that means, and very, very controversial, that you're going to find out at the moment, because one of the things of organizational security is fair share legislation. Can you negotiate fair share legislation? Until very recently, at the university and state university level, union security, that sort of union security was not acceptable. And then Gray Davis had the law changed. The manual also looks at the PERB jurisdiction, and I understand that the PERB jurisdiction is expanding. What's happening in the state of California is that as the situation becomes more fluid, I guess, in some ways, is that there's a tremendous movement to try and develop sort of common standards across the state. And that you have the how employees are to be treated in Yolo or Mono or Inyo or Kern counties should be roughly the same as they're treated in the seriously large counties in San Diego, Los Angeles, and San Francisco County and City. So you have PERB jurisdiction there. And the other issues that are important are the dispute settlement mechanisms in the state of California, how they are to be dealt with at the local level. California is a little unusual in that it has some charter cities that specifically have language allowing arbitration, binding arbitration for collective bargaining disputes. Most other jurisdictions don't. They allow you to go to mediation and fact-finding, and they will allow arbitration at the individual dispute level, but not at the contract level. So again, this takes a look at this. And then it looks at unfair practices. What can what does management do that could be considered unfair? Basically, refusal to bargain or refusal to recognize an association for collective bargaining purposes. And what can the union do that's unfair? Rather similar stuff. Or they could sort of try and impose other sanctions on the local jurisdiction that would be considered unreasonable and unfair. So that's the Myers-Brown Act is a very clever piece of legislation designed to fit the times, to allow it allows the local jurisdictions a wide variety of latitude in determining how things, and now you're seeing that the essentials of management essentially require that you have some sort of standardized things. At the other levels, the other large-scale public entities in the state, the university system being one, there's a specialized piece of legislation called HERA, Higher Education Employee Relations Act. And there, the trick was, how do you integrate a specific university institution called a faculty senate into collective bargaining operation? And they've decided to do it in two different ways. The University of California allows its faculty senates to have a tremendous amount of authority, and they can, in a sense, face down a president or a campus chancellor, as they're called in that system. In our system, in the CSU system, we have one bargaining unit for faculty for the whole system. It's 23 or 24,000 people in the one bargaining unit, and it's the faculty senates. The role of the faculty senate is significantly more limited than it is in the university system. So the legislation allows for that sort of institutional variation. And for those of you that are working in the university system or in the CSU system, perhaps a good thing to do would be to take a look at HERA. The other big piece of legislation is ERA, Education Employee Relations Act, and that deals specifically with certified or certificated and non-certificated employees at the K through 14 level. And it takes into account the rather peculiar ways in which schools are funded, the school year, how awkward it is. So they have how many days, they'll negotiate how many days you have to have, or how many hours and periods are in a day. So the legislation is very, very clever, very reasonable. The legislation emerges in response to the particulars of a job situation, whether it's in K-12, whether it's in local government, in state government, or at the university level. Then there are the specialized pieces of legislation covering police. And take a look at the introduction to this particular book, and it'll give you a overview of the actual laws in California. So you get an idea that there isn't. Well, the first thing, of course, is there isn't a standard law that covers everybody. Two, there's two different sorts of laws. There's ERA, HERA, and CERA that cover the vast majority of education and state employees. And then there's this peculiar thing, Myers-Brown, which covers local government employees, that is city and county, special district employees, and so forth. So those are the main things. And the legislation also gives you, or the discussion on the handbook, it'll give you an idea of what are the important issues covered under this legislation. And the second part of it actually attempts to give you an up-to-date version of what the court cases, what the court decisions are on any one of these particular topics. Where is currently the court on the question of the right to strike, for example. So it's important that you take a look at that also. Okay, guys, later.